I'm glad you're all here.
Thank you. Well, we're grateful that you're opening the doors to all of us. We're very interested in making sure that the civil rights of our children living with autism and other disabilities are protected. And we know that you want to do the same thing, so we're all working for the same purpose. We have a few people here that we'd like to present to you a petition and also give you some information about autism. First of all, we have Army Captain Royce B.
Congressman, I'd like to give you this petition on the Case Amendment and explain to you a little bit about our personal situation. Had it not been for the attorneys that we retain, we would not be in the position that we are now to offer adequate education for our son. In the constant conflict between the Department of Education, the schools, and ourselves, we were making it absolutely nowhere until we retained a lawyer. Once we retained a lawyer, the legal process took over. It was a little smoother, and it enabled us to put our son in a position to learn. These children can learn. However, if they don't have adequate legal representation, they're not ever going to make it to a position to learn. So basically the petition that you have in front of you is our standpoint that we want to ensure that we are able to retain the best possible legal representation to assist our children. If we put a cap on that, we're not going to be able to do that. We will not be able to adequately attain the best attorneys to represent our kids. That's our position, sir.
Introduce Mr. Mark Eisenman from Maui. He flew all the way over here with his family to meet you. This is Mark Eisenman.
Hi, Mark. Hi. This is just a friend of mine from the class. What you have to understand is that autism, my child is basically, Marcus is in an institution right now in Oahu because there are no facilities in Maryland. We've literally gone to the trouble to build him a cottage that he can live in now, assuming that we can get services, educational services, and services to meet his needs. However, that hasn't been done. I've literally built a cottage for him with my bare hands over the past 2 years, bringing him about $100,000 in debt, and keeping him over here for 2 years as a result of they didn't have the facility. They basically, he stays over in Kahimahala. He has for 2 years. He goes to Loveland, and he requires a one-on-one aid with him all the time because he was basically trying to front a bus or a car. He has no fear of danger, and he would die within probably a few minutes in the event that you left him. So we're trying to find solutions. We work hard to find solutions. This is not an easy problem to solve, but we've worked hard at it. And I feel like that basically what we don't want to do is we don't want to be in a position of losing the rights for our children because of not having legal representation and because of the fact that the DOE, in my son's case, last year in September, threatened under CPS should have taken 2 seconds, under CPS to basically nail us to the wall, and this was done through the new transitioning of the DOE from the DOH and so forth, and we finally had to go through the process of the hearing officer and so forth. They said in the hearing officers that the DOE did not have the ability to do anything from September of last year till to date to come up with any solutions on their own, yet they were willing to threaten to send me to CPS as a bad parent when I've done what I can do and all that a human could possibly do to make this happen. And so I feel like that you need to look at that everybody. This legislation affects the entire country. There are hundreds of thousands of us, probably more like 500,000 of us that this affects. And it's one thing to knock us around, okay? It's another thing to knock our children around, and those children need those services. And we're going to fight hard to keep them however we can. And we feel like that as our representative that you should fight hard for us to keep them also, because they may not be perfect children, but they're our children. And they mean a lot to us. Thank you. Thank you.
We're a military family. We moved in. We arrived to Hawaii a year ago. We've wanted to make Hawaii our permanent home, but with the educational system currently standing the way it is, chances are we're not going to have that option. My son is extremely high functioning, as you've met Tyler. So for us, getting services is even harder, but that much more critical because he is a child that can make it. He's a child that can become a fully self-functioning, self-sufficient, productive member of society if he receives the help he gets. We've gone a year now without any services whatsoever. We've spent every bit of money we had in the bank. And the only way that we've even been able to remain here to begin to get services is with the help of our attorney, who is by no means getting rich off of our case. He willingly, to help us settle our case, dropped his fee by more than $2,500 simply as a matter of trying to help us.
There's no other civil rights attorneys that we know of that are put under these kinds of conditions. And we know what it's like and how to get the attorneys. And it is very difficult. You don't know how hard it is. The majority of the parents here would like to have an attorney. The majority of them will not. There's only a few, like Mrs. Vanderlack, like Mr. Eisenman, who's willing to put their file together. The attorneys will come in, and none of these parents you'll see are, the attorneys are charging them up front. And many of the parents, when they come up to me, they say, Naomi, you know, I can't afford an attorney. I'm overwhelmed with this 24 hours a day. I have a job, I have a family, I have a husband. I'm trying to keep everything together. I don't have that kind of money around. But in order for the parents to even have half of a chance, they have to know IDEA, and they don't know it. They don't know that they actually have rights. Not until we can come into a meeting and we go down a list of things that are happening in the IP meeting that we realize that, my God, they have rights, and their children should have equal access like any other student or child in the world, in the United States, to have access to that education. And what we see has happened to Tyler. And this little gentleman here, Mason Speaks, his father just talked a little while ago, Aaliyah, who was in the arms of Mr. Eisenman. You know, you didn't see what they were like before. Now they have a chance. And the only way it's going to happen is when the attorneys actually say, okay, I'll do it. And one of these attorneys is right here, Chris Parsons. He didn't want to come, but I asked him to please come because he's one of the attorneys that did not charge in order to take a case on. Otherwise, Mrs. Vanderlack and Tyler would be in a really sad situation right now.
Congressman, I think just to make clear what the problem here is from our point of view. I was a hearing officer for the state, and I heard these cases, and I had families come in front of me, both represented and unrepresented. When the Department of Education decided to do away with the independent hearing officer system and move to a system where they use all state employee hearing officers, my phone began ringing with parents who were looking for attorneys who would take these cases. Most of the families that have called me are not in a position to be able to pay anything up front. They basically need help, they don't have money, and they have a case. And the only way this type of a family has been able to get representation has been with attorneys. In my case, let me just make it clear. In my entire legal practice, I've done 4 special ed cases so far. So this isn't a cash cow for me. This isn't how I make my living necessarily at this point. I've taken 4 cases. But I can tell you that each of those parents that came to me have been looking for attorneys for a long, long time. And they've been unable to find them. And in each of those cases, I felt that their case was so obvious, that the violations by the DOE were so egregious, that I simply couldn't let it go without taking the case, knowing that if I won, I would be reimbursed my usual rate of compensation as determined by the courts, what an attorney of similar competency and experience in the marketplace would be paid, as they are with every other civil rights law. I think what the parents are having a hard time understanding is why we would give the opportunity to the governor, who is in essence the person being sued by these families when these people go to court, and give the governor the opportunity to set the rate at which their attorneys are being compensated. It seems to us to give the governor the tool not the certainty, but the tool to simply lower those rates to a point where they can eliminate virtually any opportunity for these parents to have attorneys. The upset is national. All of us have been contacted by attorneys and autism and learning disabled community from across the country saying, who is this Congressman Ed Case? Is he a Democrat? Why is he doing this? We're all getting inundated with these emails. The amendment that you've put in is the amendment that you've put in is the rallying point at this point against the IDEA reauthorization bill, which I understand you voted against when it left committee. You put this amendment in, this onerous amendment from the point of view of most of the parents, and certainly from my point of view, I would not have been able to take the cases. If they lowered, right now my rate is not a high rate as attorneys in Hawaii are charging. I charge normally $185 an hour, okay? But I only get paid, remember, if I win the case, okay? And I have 5 employees and an office and computer costs and everything else that goes into that. I can tell you that this is not, let me just say that I've had a hard time getting my partners to allow me to continue to practice in this area. Let me put it that way. It's not like when the DOE is not going to be with, their attorneys are not going to be restricted. You know? When the DOE needs an attorney, they're going to have an attorney. But the parents that I've represented so far would not have an attorney had I not taken the case. I mean, literally. So I just want you to rethink what you're looking at. In your case, you're putting the fox in charge of the hen house. You're letting the guy who's being sued set the rate at which the people who are suing them can pay their attorneys. Their attorneys will be paid, unlike any other civil rights law. There's no other civil rights law where this is the case. I would ask you, what makes IDEA cases different than ADA cases, Civil Rights Act, 1964 cases, all the other cases that are brought under Section 1983, where we recognize that parents ought not be put into the poorhouse in order to enforce their own civil rights? What makes the parents of special ed students different than all the other people who have to fight for their civil rights in the federal courts?
Enough time this morning, and I've got some people that are waiting outside for me. And I made a special effort for you to try to fit you into a very busy schedule. But I am coming back in May and then June, so I'd be happy to provide us more time, because this happened on quite short notice. First of all, as you all know, we are in the middle of a major reauthorization of IDEA. My observation is that we all want to continue IDEA. We are not looking to, do away with this law. This law has been in effect for 31 years now. It has been in effect since 1972.
And the reauthorization has been in effect since '97, and it's adequate.
Well, I think that there are some differences on that, to be quite honest with you, and that's where we are in terms of the debate. We all know that it's been a problem here in Hawaii. We all know and I believe that the lawsuit from the early 1990s was the only way to effectively require compliance with IDEA. So that, I think, we're all in agreement on. By the way, before I go any further on that, you're correct, Chris. I did vote against this bill. I voted against the IDEA reauthorization as it came out of committee because I believed that although my amendment was accepted, on balance, the bill was not what we wanted, was not the right balance of what we wanted in terms of IDEA. And there were basically 2 areas for that. The first was, I think we can all agree, that the biggest problem in my mind with IDEA is the federal funding levels. As you all know, in 1972, when the federal government enacted IDEA, the undertaking was that the federal government would fund 40% of the cost of IDEA. Now, until 2, 3, 4, 5 years ago, that was under 10%. And that raised a tremendous burden for the states, which was reflected right here in Hawaii. So there was a federal mandate that nobody disagrees with, but frankly, very inadequate funding from the federal government to be able to carry it out. My effort has been to increase that federal funding for IDEA. I think that's the number 1 issue with IDEA. How much money is the federal government contributing to IDEA? Now, before I got to Congress, through a lot of hard work, I think the federal share had gotten up to somewhere around 17, 18%. During the same committee deliberations that Chris refers to, there were several amendments offered to fully fund IDEA here, and I voted for those amendments. Finally, and those amendments were turned down on straight partisan votes. those amendments would have increased it to 40% right away. And then there was an amendment that would have phased it in over 5 years to 40%. I supported all of those amendments. I think that that is the problem with the IDEA. Primarily the problem is a lack of funding to carry out what you all are looking for and what we all want. So that's number one. And what we're really dealing with here in the big picture in the federal government, which I'm dealing with, is are we making enough money available to finance all of these services, including IDEA? This is an issue of the tax cuts that are being proposed by this president. Massive tax cuts. If we do those tax cuts, we won't have money to fund IDEA, even at 21, 24%. So that was one of the problems with this bill. There were a number of other unresolved problems that, from my perspective, made it impossible for me to support it as it came out. And I felt it was necessary to basically send the message, as I voted against it, that we needed to resolve these things in conference. So let's go back and recall that what we're dealing with here is the very first stage in this process where the committees determine what they propose. This is now going to go to the floor of the U.S. House of Representatives probably within the next 4 or 5 weeks. If it passes, and I believe it will, then it'll go to the Senate. From the Senate, it'll go into a conference. There's a lot of time left to work these things out. So right now what we're dealing with is a pretty fast-moving train, and we just need to keep talking with each other. Now, some of the areas that are still being discussed and will be discussed by all of us that I look for your input on are the actual administration of IDEA in the schools, where the special needs community believes that essentially things are not going well, and neither do the teachers or the administrators. And they're all coming into Congress at the same time to tell us what is needed. Now, we have not come to a meeting of the minds yet, be real blunt about it. On a number of areas that still need to be discussed, whether we're talking about discipline issues in the schools, whether we're talking about IEPs, and whether we're talking about attorneys' fees. What I'm trying to communicate to you is that my amendment was and is part of a much bigger picture, where we're trying to make IDEA work better. Because if this amendment is going to dry up the pool of available attorneys in Hawaii,
we already know it will.
I would like to know that for a fact.
It gives the governor the tool. We don't know what the governor will do. What we know is that the governor is the person who's in charge of making all of the budgetary balancings that have to be made, that our schools are funded from the general fund. And it just seems anomalous to allow that person who's in charge of that, ultimately the person who's being sued, to set the fees for the opposite side. It's not that it's going to necessarily do it. What I'm saying is, if the governor chooses to cut the fee to half of the going rate, which is what we get paid now, probably the whole universe of attorneys who practice in this area is maybe 250 in the entire country, because it's not lucrative. It's 80% women. It's women who have connections to kids with disabilities. This is not an area, contrary to some who use rhetoric. This is not an area where attorneys are becoming rich. The idea that the problem in the system is attorneys is ludicrous, and I think all these parents would tell you that it wasn't until an attorney got involved that the DOE started dealing with them like they were adults and like they had sense. So, I think our concern is not that it will dry it up, it's that you're giving the opportunity to do that to the governor of the state, whoever that governor may be.
Well, again, the intention is not to cap attorneys' fees. The intention of this amendment is not to limit the availability of attorneys.
Only how much they can be paid, correct?
Well, that very much relies upon an assumption, I think, Chris, that you're making, which is that a governor of a state would be motivated to reduce those fees as low as possible in order to dry up attorneys that would, in fact, represent children, and that is not my intention.
Well, I can tell you that everybody here knows that the atmosphere between the Department of Education and the parent community is extremely poor.
If that is something that needs to be cleared up in the course of the discussion, I'm happy to go there, because, again, this amendment is not intended to cap, an outright cap. By the way, I should note for you all that some parts of our country are proposing caps. For example, the Texas school boards wrote me and said they want a $5,000 cap per due process hearing. Now, I think that would dry up attorneys pretty fast. I think that I'm not sure whether they did do it, but I think they took it back. But I'm not really positive of that. And Chris, what you're saying is you're bothered by the fact that the governor is setting these rates.
Every other civil rights law, the courts decide what a reasonable rate for a given attorney is. I've been awarded fees in other cases by the federal court. They look at other attorneys of similar experience and quality of service. They look at the quality of representation in the particular case, and a federal judge or a federal magistrate sets the rate that attorney will be allowed to do. The only thing your law does is it takes that decision away from the federal court, which has experience in that and has standards for making those decisions,
right,
and puts it in the hand of an elected political representative whose budgets are directly impacted by those awards.
Because the system that you're talking about where the federal court sets those rates is after the fact.
Then are you going to be now recommending this for all other civil rights laws as well? Because if it works for this one, wouldn't that be the same principle for everything?
Well, I really don't know. I mean,
well, why are these folks different then? That's the question. Why are parents of special ed students the ones that are going to be used as the guinea pigs in this new approach? This has never been done
essentially
before.
Because as you talk to the national organizations that are administering IDEA, as you talk to the national school boards, you can't dismiss their concerns. They
don't want lawyers fighting them because they lose to lawyers. In Illinois, 30% of parents win when they're unrepresented, 70% win when they're represented.
I don't doubt that attorneys are necessary. I've said it already, and I'll say it again. I believe in the system of attorneys being available. I believe in the system of successful attorneys representing IDEA children to be compensated by a state. Okay, I don't disagree with that. So I don't disagree that attorneys are necessary, and I'm not surprised that they succeed. I'm not willing to make the next leap that you're making, which is that the state would be motivated to dry up that pool of attorneys and would want essentially to do that. And it's certainly not my interest. So you're ascribing a motive to the governor of any state that I'm not ready.
I said it puts the tools. The incentives are all there. All I'm saying to you is if you go, you spend time meeting with the parents and you get into a little bit of discussion about what their relationship has been with the DOE and the state, and you look at the history of Felix, and then you tell me that the chief executive of the state ought to be the one that has the tools to govern the availability of legal representation for the parents. And I just don't see how the case can be made.
You can think of a better system of putting somebody else in charge of setting those rates.
Well, why not the courts? Why not the federal judges who have had that right?
Because the basic problem is that it is after the fact. The basic problem is that there is uncertainty at the front end as to what rates are or are not reasonable.
If
That's
they
the problem.
If they live up to the federal law, there is no concern. If they simply follow the federal law, these are not close cases. If they simply do what they're required to do under the federal law, the issue of attorney's fees never comes up. These are only the most egregious cases where parents have gone through years, in some cases 8 years, the most recent case.
Well, that's clearly an issue of continued discussion, because I will tell you, again, trying to listen to both sides of this question, and again I will say, this is an area where unfortunately there's polarization, and I'm hoping that what we can have in the remainder of the discussion in Congress is everybody trying to understand the other perspective and trying to find some ground that works for everybody.
These people have been trying for years to do that. And let me just say, they live with kids with disabilities every day, every week, every month, every year. From the time their kids hit 2 years old, it's the prime thing that goes on in their lives. They know they don't need to understand the other side. What they need is another side that's responsive to parents and doesn't treat parents like enemies. You know, now we're talking about walking away from No Child Left Behind. You know, Hawaii will be the one state or one of a handful of states.
I'm not talking about it first.
But I'm saying that this is the culture that's going on now. Rather than meet our obligations to the kids, we'd rather take the heat off. And that's what your amendment does. Is it gives them another way to take the heat off.
I don't agree with that. But if you want to discuss it further, well, I think that we can probably discuss it. Wouldn't you agree?
I agree.
Okay,
no, I
let's
agree.
do that.
Absolutely, I agree. And I think all of our concern is to see our congressman introduce this amendment. It was a shock.
Well, your congressman is interested in full funding of IDEA and the administration of IDEA, which allows any state to administer it the way that it was originally intended, and for special needs children to be helped. This is a part of that, but certainly in my mind, not the biggest part of it. So we can continue to discuss how to refine this, and we've got time to discuss it. And I commit to discussing it with you, because I'm not trying to to revoke IDEA. I am trying to help the community. I've dealt with this in the state legislature for years now. Now we're in the federal government, and I will tell you very straight that there are genuine disagreements among well-meaning people over whether and how to make IDEA better. And that is the discussion that's going on in Congress right now, and we have time to get through that discussion.
And please don't jump into limiting attorneys' fees until you have a better idea. Until this state implements the Felix Consent Decree appropriately, until there are real programs, it would not serve the children that are in this room right now. I am fully aware of Patricia Hamamoto's letter to you asking you to cap the fees. I am aware that at the time you were asking for input from the community on education reform, we had sent you information. We have not received any information from you, but you definitely placed her memo to you as a high, or letter as a high priority. We represent the needs of the children. If these children go without education 1, 2, 3 years in time for the Felix Consent Decree to someday take effect, these children will be lost. We're only looking to save the children, and that's all we're asking you to do. So all we're asking you to do is please do not give the governors the right to make that decision. It should stay within the judiciary, and we're asking that you keep it there until we can develop an appropriate system of care.
Okay. Well, we've got a little time to work this out, first of all, so I will definitely...
Could we possibly set up a meeting the next time you get back into town where we could all sit down and maybe we could be a part of the discussion, and that way you could get our side? It's not fair not to have our side, because we've been the ones that have been terrorized in the IEPs, and there's many across the strait and many across the United States. I came from Texas. I've been to those IEPs where they have where the school boards have the money, and they basically use the attorneys as whipping posts to keep people in line. And so it's not just here; it's everywhere. And I assume that you represent not just us, but you'd like to see it work for everybody. And if that's the case, and if we could be a part of the solution, definite meeting to where we could sit down and talk.
So the point I want to make here is that I just don't want to let your statement go unsaid, or the implication at least that somehow I'm only listening to Mrs. Hamamoto.
It's because Mrs. Hamamoto invited us to attend a meeting on the very thing that is represented in her letter. And the meeting was supposed to take place in March. I called and said that we would be there, and her office said, it wasn't her office, it said the farmer's office. Said, I'm sorry, the meeting is canceled.
Yeah.
So,
well, I regret that.
There'd be no limitation as far as subjecting or conditioning it to an individual who does not have expertise in that area. That's like putting our children with mental health needs in the education system, who has absolutely no idea when our children are having a major breakdown.
Again, I think that there's middle ground here, and I'm not sure I agree with the statement that you just made, but we do have, I do commit to talking with you about it further. I'm back here, I think in May, as I recall, a couple of times. So
I'm sorry to interrupt. Your 10:30 appointment is here, along with your 10 o'clock appointment.
10 and 10:30. Again, I'm sorry that this was so short and that I didn't have enough time for all of you.
Thank you for making time for us.
Thank you very much.
These are copies of the amendment in case any of you haven't seen it, just so you all know what we're talking about. Please feel free to take them.